Good afternoon. We are back for a very busy landlord tenant and civil docket. I've tried to move some things up and not sure how that's going to work. I've tried to move some things from later in the afternoon to earlier in the afternoon so I can get somebody to a airplane flight. So we'll be starting here in just a minute. I think Brian from Seattle is going to come back for the afternoon. Someone reminded me a little earlier today, 42 years ago today, I got my bar exam results, November 6, 1981. And that was a long time ago. 87% of my classmates passed the bar examination that day. So we're going to hopefully start right at 1 o'clock. And then I've got things on very short time frame. And I've got a couple discovery hearings and we're going to do the best we can. Today is the first day of the new landlord tenant court rule. So I will be using a new, longer advice of rights, which is required by the Supreme Court. Yeah, we're not sure what time it is. The clock in the courtroom says 1:20, 1:55, but we know that's not right. We're all sort of adjusting, aren't we? All right, let's get going here. Thank you for saying hello. And hello to Seattle. Got a little insight on what's going on there from our visitor today. All right, we will hit the ground running as soon as people show up. Now, when you're trying to move cases, and I try not to do it, when I set something, I try to leave it set. And if I say it starts at 1 o'clock, I start at 1 o'clock, but it's hard to realign the stars on short notice.
She's out of town on the 17th. So, I mean, you can read that.
All right, well, when they both get here, we'll see if we can agree on a date.
Is he here for anything else?
On the 20th?
No, today.
Just these two.
Okay. So she can't do it on the 17th. So disregard, and if you want to use that 115 and 120 for other cases there on the 17th, you can.
Okay.
Okay.
All
and
right.
Maybe we'll have them on the 22nd, that Wednesday.
Yes, I think we were going to use that day. I think there might already be some on there.
There are. Okay, then when all this is over today, I'll reach out to both of them and reschedule on that day.
All right, well, no one's here yet. We've got 1 minute. Thank you, Lisa. She does an excellent job with organizing all of this. It's become very stressful for the staff because of all the changes, and what used to take 1 hearing now takes 2 or 3 or possibly more. Plus the volume is larger. we usually start at 1:15. That's a throwback to Judge McManus to give everybody time to get back from lunch, confer briefly with their client before we started. At once upon a time, they were all set for 1:15. And every landlord tenant case, there might have been 6 or 5 were set at 1:15. Now they're 15, 30, and we have to stagger them. But anyway, I set 1 to try to get some business done earlier. But so far, nobody's here at 1. Here's Meg from Legal Aid.
Good afternoon, Judge.
Good afternoon. Thanks for coming in early. Appreciate your help.
Yeah, I think though that Attorney Visconti and I were going to agree to adjourn.
And that's fine. We need to figure out when we're adjourning at 2.
Okay.
Hopefully he was going to be here.
He indicated to me that Attorney Carrie Zanin was going to cover for him
Okay.
the scheduled time. I don't know if she's been in the loop about the change.
Well, he's advised he's not available on the 17th. Or you're not available on the 17th.
Right.
And so that leaves Monday, the 20th. Or Wednesday, the 22nd.
Either of which worked for me.
All right. The 2 cases at issue, I'm going to turn the record on. Are Riverside versus Kylie Wilma, file 2. Let me get this flip out of the way. 231127, and Riverside versus Ashley Steele, 231129. Meg Bauer from Legal Aid is representing both defendants. Robert Visconti is representing Riverside Townhouses. These matters have been adjourned several times. The amounts at issue have gotten narrowed down considerably, but not crossed the finish line. Both counsel advised they thought they would be able to get to a settlement, but they haven't quite gotten there. I had scheduled these matters for 2:30 today. I asked to move them to 1 o'clock. And I thought Mr. Visconti had agreed, but if he's not available, maybe Ms. Bauer doesn't know. Ms. Zanin doesn't know. Meg Bauer is here on both cases.
I did
And
both attorneys
you
and
had
Visconti.
you had discussed moving the cases with Mr. Visconti one more time.
That's
Is
correct.
that true?
Yeah, I didn't mean to speak over you a second ago.
And what is it you lack?
I had requested access to the tenant file from Mr. Visconti after our previous hearing. He wanted to get that from his client and then send it to me. He has not gotten communication from his client at this point. So the purpose for that is that there's a dispute between when changes were reported.
Yes.
The disputes in the 2 cases are slightly different, but the timing of reporting is the crux of the issue.
Wednesday, November 22nd is a jury day, but for several reasons, we aren't going to have a jury trial that day. So I'm using that for landlord tenant matters. We could continue these until 10 a.m. on Wednesday, November 22nd. Does that work for you?
I believe you scheduled another landlord tenant case at 10 a.m. on Wednesday, November 22nd.
If I have, it hasn't made it to the docket yet.
Attorney Thornton and I are discussing, or have both consented to that time for Sturgis
well,
Place
how about-
Apartments.
How about 10:30?
Yep, that's fine.
Looks
with
like
me.
you'll be here anyway.
Meg is correct, there is one at 10 a.m.
All right, we'll go to 10:30. Meg, you're gonna be here with me for a bit anyway, so let's wait. If anyone comes, we'll address this, but
That sounds good, John.
I'm gonna continue both of these to the same time. Hello, John. That's the day before Thanksgiving, and historically, no juror wants to be on jury duty on that day anyway. And I think I'm the only judge in residence that day also.
And Judge Northman have a jury on the day before Thanksgiving once.
Yeah,
I think the ladies were all looking at their watches.
yeah, I think everybody wanted to get out of there. They had stuff to tend to, but I think he was hopeful the case would settle, but must have been me, so we didn't settle it.
It might have been a long time ago.
Mr. Bush is up next at 1:15. John, this is the first day of the new court rule, which we are all trying to comprehend.
These are both lot rent cases.
Yes, they are, and we'll see who's here. If they both show up, I won't have to go through the rights twice. They're probably half again as long as they were before. Good afternoon, Motorola Moto G. Can you hear me? I have a 120 in here with Ross Truckee and Lance Thornton, and I'm really hopeful that case is settled. They were waiting for a check to clear. Good afternoon, Motorola Moto G Stylus, whose name is unknown. Could you hear me, please? John, these accounting sheets are just very, very helpful. Meg, do the attorneys in Kalamazoo do those the way that John Bush does and Lance Thornton and some others that help understand the issues?
Generally speaking, no. Occasionally they'll pop up, but I'm not sure if it's the evidentiary foundation question or just a practice issue. But no, I don't generally see those outside of this court.
I guess they aren't taken as gospel, but they are a place to begin from. and have an understanding of how the costs are compiled. All right, I've still got Motorola G stylus with no sound and no picture. And can you hear me? Doesn't even show a microphone. Motorola G stylus, can you hear me? Someone is there. I'm gonna remove them. See if they have any better luck this time. Apparently, Miss Zanin didn't get the message about moving the case ahead, but we'll deal with her when she comes. You'll probably still be here.
Judge, looks like Attorney Zanin's on her way.
All right. Good afternoon, Ms. Corpening.
Good afternoon, Your Honor.
Welcome
John.
back.
Oh, Chris,
Someone has attempted to log in without success. We couldn't hear them or see them, so I removed them. And hopefully they'll be back. I'm on a very tight schedule this afternoon. This is the first day of the new court rule. And I won't say we've completely assimilated it, but we're going to try to comply with it as best we can.
We finally got those FAQs that we were looking for, Judge.
Yeah, Thursday. And it did have a click through to the court forms. And so I got my first look at the forms. And the new complaint has information about residential property was kept fit for the use intended and other language. And some other language. All right, here's Carrie Zanin. Good afternoon.
Good afternoon, Judge. How are you?
I'm good. I'm here with Meg Bauer on your two cases. Attorney Carrie Zanin has joined us, assist Robert Visconti in Riverside versus Wilma and Riverside versus Steele. Wilma is 231127 LT and Steele is 231129 LT. There are issues in both cases where legal aid was trying to get a look at the client file. And Mr. Visconti hadn't been able to get them yet. So she said they had discussed things and agreed to move this one more time. She's going on a Caribbean vacation or something, and she's not available on November 17th. Are you available or Robert available on November 22nd at 10:30? That's a
Judge-
Wednesday.
10:30. Yes, we can do that, Judge.
All right, let's adjourn both of these cases to that date. She and Robert can continue to communicate. We gotten both cases close to the finish line, but not quite there. And I appreciate your help. We'll adjourn both of these to November 22nd at 10:30. That's a Wednesday, and that's an odd time for us, but we'll make it work.
Thank you, Judge.
All right,
figured
thank you. Thanks.
I figured
Thanks
you
for
and
helping.
absolutely. I figured you and Attorney Bowers wanted to see how fast you could get me to jump onto court.
Okay, you're good. Come on.
Thank you.
Take the rest of the day off.
The record straight, I am also a hunter.
Oh.
My
Oh.
family has some property in the opposite direction of the Caribbean, although I won't be joining them.
Well, you won't cross paths with Judge Pattison. He stays close to home here. All right, good for you. All right, Carrie, thank you. They keep setting the domestic relations conference for November 15th, which drives Judge Pattison nuts. It's one of the biggest conferences of the year. And so this year they moved to the 16th. And he said, obviously, none of these people care about that. Chris, we have two memory lane cases. One is at 115 and one is at 125. As I indicated, someone was trying to log in. I have a case in the middle, which I think is going to be dismissed. So we'll just sit here and John, have you got to be upstairs or is
I
this?
have to be upstairs at 2, so I think we're in good
We'll
shape.
get you out of here by 2 no matter what happens. Chris, it's good to have you back. Matt is okay, but he doesn't have all the answers that you have. So
Thank you.
are these clients both still there? Marvin and
Yes, they
Esther
are.
Stutzman and Cody Boyer?
Yes, they are both still here.
Now, I won't be here next Monday, John, November 13th. And so we'll have to look at a date to put these. Which would take us, I think, to the 17th, Friday. Let's see what we've got. All right, let's see who iPhone is, if they do any better than Moto. Good afternoon. Can you hear me?
Yes, I can hear you.
Are you Esther Stutzman?
Yes, I am.
Is Marvin there with you?
And no, I think he was trying to join in.
Well, somebody was trying to join in as Moto G and they didn't have any luck because they didn't turn their camera on or their microphone. Is he there with you or is it a different location? Ms. Stutzman, is Marvin there in the house with you or is he at another location? You've turned your microphone off. I don't really have time for this today, but I think we're probably going to get a lot of it. Esther, can you hear me? I did hear you, and you've got your sound turned off. Another Hyundai, another ceiling fan. Boy. Ms. Stutzman, could you turn your sound on?
Sorry, I was helping my husband get the ID number.
All right, where is he?
He was trying to join in, but he couldn't.
But is he there with you at home or is it another location?
He's at the job.
Oh, okay. Oh, at least he has a name. All right, there he is. This is Memory Lane Mobile Home Park versus Esther and Marvin Stutzman. Mr. Stutzman, can you hear me?
Yes, I
Yes, I
can.
can
Can you
see-
hear?
All right.
Can
Could
you hear me?
remove your hat, please?
Oh, sorry.
All right, well, that is a court proceeding and people don't tend to acknowledge that, but it will make this work. Your landlord is asking you to move. It's filed as a just cause termination of tenancy, alleging that your rent has been late 3 times in a 12-month period. So they want you to move out and move the mobile home. Now, Mr. Bush gave me, and hopefully you received this, an accounting to show how much the rent is. We'll talk about that in a minute. As soon as I finish this, Mr. Boyer will show up and I'll get to do it all over again. But this is the rights you have in a landlord-tenant proceeding. You have the right to hire an attorney. If you cannot afford one, the court can give you information about legal aid and any assistance that may be available in your area, although they don't represent every case. You have the right to have the case heard in the county or district where the property is located. I don't even know why this is in here, but this always happens. Look at item 3 on the attached summons. If the landlord has checked the box saying that the case is not being brought where the premises are located, you can ask the court to transfer the case to your county or district. You can ask the court to move the case by filing a request in writing listed on the summons. This has never happened once in the entire time I've been doing these, but it's in the new instructions. Jury trial. You have the right to demand a jury. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. Who? Yes, he can come in. If you want a jury trial, you must tell the court at your first appearance or then make the demand within writing. You can use the form MC-22 jury demand and file it with the court. You must pay a $50 fee when you make the demand, or within 5 days of that, explain your right. And within 5 days of me explaining your rights to you. You do not have to pay the jury fee if you receive a fee waiver and the court has approved your request for a fee waiver. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from, oh, here's Cordy Boyer. I gotta do it all over again. The Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource recovery agency, that's HARA. Here's in this county, it's the Neighborhood Housing Association, or possibly a veterans program. You should have received that information from the court with the summons. You do not need a judgment against you to receive that emergency assistance. A summons and the complaint from your court case are enough. If you do reach an agreement with the landlord by going through a local community dispute resolution, you can find that program. And what I say is you may be eligible for mediation if both parties are interested. If both parties are interested, I will schedule the matter for mediation. So far, that hasn't happened. You may be able to reach an agreement with the landlord, what it means to get this case dismissed. The court will provide you with a form for this and tell you where to find it online. If you reach an agreement in a consent judgment with the court, you would waive the rights listed above, but the judgment could not be enforced until 3 business days had passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a landlord-tenant hearing. The law requires that I continue this matter for at least 7 days to allow you time to get legal assistance if needed. According to Mr. Bush, the rent through November is $1,495. There are $240 alleged to be due in late fees and $232.68 in costs, for a total of $1,967.68. But what they're actually asking is for you to move. Now, Chris Corpening, your manager, is here. She has the discretion to change that. But right now, that's what their request is. Ms. Stutzman, what's your position? Do you two wish to remain there?
Well, if that's how she feels about us, I guess we didn't know that about the $1,000 on November. That there is new to us.
Well, that's just their contention. So that
No,
hasn't been.
if that's what it should have been, she should have told us from the start before she came to this with this court hearing.
Well,
She
they
should've-
filed the. She did tell you. On
No, she
June
didn't.
6th, they filed something, say you owe $2,005. On August 8th, they filed something saying you owed $1,425. On September something, they filed something that said you owe $2,565. So this didn't sneak up and bite you in the ankle. But at this point, they aren't even asking you to pay, they're asking you to move. So Meg Bauer is here from Legal Aid if you wish to consult with her. But the law requires that I set this for a second hearing, which would be Friday, November 17th at 11 a.m. Does that work for you, John?
Yes, it does, Your Honor.
I'm certainly happy to speak with the Stutzmans. Judge.
Mr. and Mrs. Stutzman, do you wish to speak to Ms. Bauer from Legal Aid?
That's up to you, Marvin.
Your Honor,
Oh,
I,
yes.
if I can resolve this issue out between the park manager with catching up on the rent and getting ahead on rent, that would be my
Well,
wish.
All right, you can do that through what I described as a conditional order for dismissal. Now, I want
Right.
you to be clear. If they get what they're asking for, you would have 10 days from the 20th of November to move out and 90 days to move or sell the mobile home. And they gave you these numbers so you know what it is you're working from. She has discretion to alter this and enter into an order for conditional dismissal. So she's
Right.
here, she's heard what I've told you, and she's always available for discussion. So nothing is going to happen until I see you on the 20th at that time. Do you have any questions?
Excuse me, I think you said the 17th, so which day are we?
Friday, November 20th is what I meant to say.
I think 17th is a Friday.
No, it is Friday, November 17th. The 20th is a Monday.
You said Friday, November 17th?
Correct. Friday, November 17th. I'm not here on the 13th.
What time was that?
That would be
11
11 a.m. We'll get you a new notice. So I would suggest you talk to your manager before that.
What my question is how much do we still owe? My wife took she took $700 up there this morning and give that to Chris, the park manager. My curiosity is what is the balance that we still owe?
Well, that would leave $1,267.
Okay. Well, that's
Then we
that's
run
many.
into the issue. Then we run into the issue where she's accepted rent on a termination of tenancy case. So that could be a wrinkle. But you can see if you can reconcile the numbers, but if you paid 700 this morning, that would reduce it by $700.
Right. I would personally like to speak with Chris, the park manager, try to resolve this like human beings, like adults, if you know what I mean.
I understand. Chris, what would be a good time to meet with them?
I'm here till 4 o'clock today. I'm here actually every day from 9 to 4.
All right, any day, 9 to 4.
Yeah.
All right,
Good.
I will see you on, sorry about the confusion of the date, Friday, November 17th.
Okay. I've got that time and date wrote down, and I'll put it in my calendar.
We'll give you a new notice, but thank you. Ms. Stutzman, do you have any questions?
The question I have for Chris is,
No,
how's
do
she
you have
gonna
any
feel putting a family out with a disabled child?
All right, do you have a question for me? All right, we'll leave it at that. Mr. Stutzman, thank you.
You're welcome.
All right, Mr. Boyer will be with you in just a moment. Mr. Truckee is present live in person. Mr. Thornton is here by Zoom on River Run Estates versus Catherine Woods. And I'm hoping you have some good news for me because we're already way behind schedule. What can you tell us, Ross?
Well, I would leave it to Mr. Thornton.
Okay, Your Honor, I called my client just a few minutes ago. He physically got the check on Saturday, 11/4, November 4th. He cashed it the same day and deposited it in the bank. He's waiting for that to the couple of days it's going to take to clear. I don't want the court to reset this for a hearing. I cannot say we're dismissing, but I can say as soon as I get the email, I will file a dismissal that when we confirm that the check's cleared. So if the court could just give us a couple of days and wait for that.
I'll tickle the matter for 7 days, indicating we expect a dismissal. And if we don't get one, we'll set a further hearing.
Yeah, I don't think we'll need it. So.
All right, Lance, I hope so. Thank you, gentlemen.
Thank you, Your Honor.
Thank you.
All right, I've got somebody in here as Moto G Stylus, and I haven't been able to determine who that is. What's your name, sir?
Jeremy Swank.
All right. Mr. Appleton is here. Let me give you a proper name. Also joining us are a couple of people for some small claims matters at 145, and we'll get to those. We're trying to juggle a number of. Ms. Stutzman, did you have anything further?
No.
All right, well, you're good to go. All right, Mr. Cody Boyer is here and Mr. Jeremy Swank. Both are here on landlord tenant matters. And as people in landlord tenant cases, Mr. Boyer, you came in a little late. You weren't late, you were on time, but you were late to that case. It's a similar case, Memory Lane Mobile Home Park versus Cody Boyer. They're asking to terminate your tenancy under just cause under the mobile home statute. And Mr. Swank is here from Mr. Appleton on a notice to terminate the tenancy. You both have the following rights as a tenant in a landlord-tenant proceeding. You have the right to hire an attorney. If you cannot afford one, the court can give you information on about getting assistance from legal aid. And we sent you that information. Meg Bauer from Legal Aid is here on the feed with us. You have the right to have your case heard here where the property is. Look at item 3 on the attached summons. If the landlord has checked the box saying the case is not being brought where the premise is located, you can ask to transfer the case to the county where it is located. This is going to be so cumbersome because this never ever happens. You can ask the court to move the case by filing that in writing. You have a right to a trial by a court. You also have the right to a trial by a jury. If you want a jury trial, you must tell the court at your first court appearance or make the demand in writing within 5 days of the court explaining your right to a jury trial. There is a specific form. It's brand new. It's Michigan Court Form 22 Jury Demand, and you file it with the court. You must pay a $50 fee when you make your jury demand or within 5 days of the court explaining your right. You do not have to pay the jury fee if you asked for and received a fee waiver. There are certain requirements for that. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, a local coordinated entry agency, a housing assessment and resource agency, HARA, or perhaps a veterans program. You should have received information on local rent and housing information with the summons. You do not need a judgment against you to receive assistance from those places, despite what they may tell you. The summons from the court, summons and complaint from the court for your case are sufficient. If you are interested in having the matter resolved through mediation and both parties are interested, we can help you make that referral and schedule it. You may be able to reach an agreement with the landlord, which means the case will be dismissed on a conditional dismissal. The court must provide you with a form for this or tell you where to find it online if you're interested in that. If you do reach an agreement with the plaintiff and a consent judgment is entered by the court, you'd waive the rights listed above and have the following additional rights. The judgment may not be enforced until 3 business days had passed. You could move to set aside the judgment within those 3 days if you misunderstood what you consented to or what you were waiving. Your motion to set aside the judgment would be set for a hearing before the judge, but if the judge did not find in your favor, the original judgment would stand. Mr. Boyer, I see you're in uniform. Are you presently in service?
No, Your Honor.
All right. Otherwise, there may be some issues regarding the Soldiers and Sailors Relief Act. The landlord filed a notice to quit alleging that you were late in your rent 3 times in a 12-month period. Mr. Bush and Chris Corpening, your manager, have filed a document alleging that your rent is behind $1,665, late fees and pet fees of $470, and court costs of $179.58 for a total of $2,314.58. Now, what they're actually asking for is they're asking for you to move and 90 days to move or sell the mobile home. What's your position, Mr. Boyer?
As I have been getting caught up on rent, but not quite fast enough, I would like to remain at my residence. I've been here for over 10 years and would like a few more years before I, try to get my own, my first house.
All
I
right.
had,
Have you contacted Stony or anybody from the VA about benefits? About emergency housing benefits?
not yet. I was just made aware of that over the weekend. I was gonna ask if we could postpone until I hear back from the Western Michigan Legal Aid.
All right, well, Western Michigan Legal Aid is here on the feed with us, and I'll let you speak to her in a moment. The law requires that I adjourn this for at least 7 days. I'm gonna adjourn it for 10. I'm gonna continue this to Friday, November 17th at 11:15. We'll make it 11:10. Now, theoretically, what they've asked for is you to move within 10 days and 90 days to move or sell the mobile home. So if they got what they asked for on November 17th, I'd give you 10 days to move out. Now, the other party that had a case before you, they're going to try to talk to Ms. Corpening and discuss perhaps working out some sort of repayment plan. I say this a lot. It's easier to keep a good tenant in there than to move one out and move another one in. We're going to continue this to Friday, November 17th at 11:10. All right, would you like to talk to the representative from Legal Aid?
Yes, I would, Your Honor.
All right, I'm going to put you in a breakout room where you can, well, the problem is I'm going to need it. So I'm going to open a couple breakout rooms. See if I can do this without getting all screwed up.
Yeah, the pandemic made it much more difficult.
All right, I'm going to put Cody Boyer. Oops. Mr. Truckee. I'm just going to do one room. That's going to be problematic.
We'll be swift, Your Honor.
All right, I don't have a lot of time. Delete. Hit the button that says join. John, does that finish your cases?
Yes.
All right, thanks. I'll see
So
you.
will they get back or are we done then? or-
We're done.
So Chris, we can exit then.
Okay, thank you, Your Honor. Thank you, John.
Thank you, Judge.
All right. All right, Mr. Lazzums, would you unmute your mic? Trying to do it. We're gonna have things all crash together at once. This is a discovery hearing in the matter of Andres Lazzums versus Richard Truckee. Mr. Truckee, can you hear me?
I think maybe right now. I just sat down
All right.
here. Can you hear me?
All right, yes,
Okay.
all right. A couple things. Would you take off your hat
Sure.
and would you please raise your right hand?
Yep.
You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Don't
Yes.
go too far, Mr. Appleton. You'll be right next. All right, this is a collection case. I made a ruling that there was an amount owed $3,001.67. Mr. Lasms is still attempting to collect on that debt. I have an inventory. Mr. Lasm, you're claiming the debt at this point is $1,367.35.
Your Honor, there's a correction to that figure. The running total, $1,460.73 as of today.
Because of additional costs for like this hearing?
Exactly. There was the posting and mailing and then accrued interest. And before that, some costs in September for filing fees. I've got a ledger that I could share if need be.
No, it's there. All right, now this is a discovery hearing and Mr. Truckee is under oath and I could put you in a room where you could talk with him privately as soon as they finish in there. But Mr. Truckee, you've paid more than half of this. I know this is something you'd like to get over with. What's your position?
Yeah, there was a balance. I believe there was a, what do they call those officers that came over for getting property or whatever?
Yeah, court officer.
Getting 2,400 cash right there on the spot. And then there was 1,300 and some odd dollars owed. And I believe that, I don't know, he's saying that it's up to 2,400. So, and
No,
that's
no,
only
no,
been-
1,400.
Oh, 1,400? Okay, I
yes.
must, okay.
1,460. What happens is with filing fees for these hearings with
Okay,
interest.
I'm
with the
fine. I thought he
cost
said,
of
I
those
thought he
guys,
said another 2,400. I'm
No,
sorry.
it raises the cost.
Okay, yep.
And so do you have the
And we were
ability
gonna
to
put
pay
that, we were gonna put that in the mail. That officer that was here, we were gonna put it in the mail with a certified check. And then the wife said that, well, you paid him cash once, why should we put it in the mail again for a certified check? He could just collect the cash again. So I talked to
Well,
him
then
again, I talked to him again today. I talked to him again today and he said he didn't care if I ran the cash to him. You know, so yeah, if you want to get me with, I believe it's Andreas, I can't really pronounce his name.
Yes.
Whichever way I got to get it to him, we can get it to him ASAP.
All right. All right. Let me close that room. So you're willing to pay $1,460.73 to get this case over with.
Yes.
And however, Mr. Lasms tells you you'll bring either cash or a certified check.
I have one question.
All right.
Real quick, and I don't know whether I should bring this up now. I have winter blankets. I have, I don't know, maybe 6, 7, 8 winter blankets that were used on his job, and I have not seen them yet. And there was also some form material that was left there, and I guess that's my question. And my couple.
Well, let me ask this, Mr. Lasms, is that stuff still there?
Your Honor, it's still here. You can pick it up at any time.
All right. When you bring the cash, you can pick that stuff up.
That's fine. Yeah.
Well, so Mr. Lasm, just soon he just brought it to your house.
That's fine.
Do you have a time?
For me, it's supposed to rain on Wednesday. When will he be there? When will he be there?
Yeah, when will you be there, sir?
I'm here at this time and we'll be throughout the week.
All right, how about Wednesday afternoon at
That's what I was
10
thinking. It's supposed to
a.m.?
rain on Wednesday, so that might be a good day for me.
All right, Wednesday, November 8th, 2023 at 10 a.m.
That would work.
Bring your truck. You can pick up your forms and your winter blankets, pay him the cash. Cash is a little tricky, so you need to make sure you get a receipt.
Okay.
Yeah. May I request
All right.
cash and then I'll itemize a receipt?
All right, cash and a receipt. All right, if it goes sideways, you contact the court and we'll reschedule this hearing. All right, you're both good to go. Let's hope that comes to a conclusion. You get your property back. He gets his cash. A lot of aggravation all around, and we'll bring closure to this. All right, you're both good to go.
Thank you, Your
Okay.
Honor.
Thank you. Thank you.
All right, Meg, I closed the room because I thought I was gonna need it. Are you guys done?
We are.
If everything's good with him.
Yeah, Mr. Truckee, you're good to go.
Okay.
Mr. Lazams, you're good to go.
Thank you, Your Honor.
Let's hope that works. All right, now, Mr. Boyer, I'm gonna remove you. Leilani, you don't have a customer here. We'll let this tick for a minute. Mr. Appleton, would you come up and have a seat at the plaintiff's side? Right here. Good afternoon, Mr. Appleton.
How's it going, Judge?
It's going good. I bet the staff $10. You would say, how's it going, Judge? So I win.
You win. I let you hear too, Judge.
Thank you. This is Mr. Randy Appleton, and his tenant is Jeremy D. Swank at a property on Driftwood Drive in Colon. This is filed, Mr. Swank, as a termination of tenancy action. You heard me go through the advice of rights, as cumbersome as they are. Mr. Appleton wants you to move. What's your position?
Well, I was under the impression that I bought this property and then it went under tax foreclosure when I was incarcerated in Indiana. And so I've been talking with some lawyers to try to see if there's anything I can do. I believe there's nothing I don't think I could do. So not a lot of lawyers gave me any very good advice so far. I've been looking.
I have Meg Bauer from Legal Aid, and I can let you speak to her.
Okay.
And then lost for taxes while incarcerated. Mr. Appleton, there's no lease, there's no sort of documentation regarding a sale or lease or anything. Was there anything, Mr. Swank, some sort of a lease or purchase agreement or something?
No, there was no lease at all.
Mr. Appleton, what's your side of that story?
My side is, Judge, I don't even know if he ever owned the property. I purchased the property through tax sale.
You bought it at tax sale.
I bought cash at tax sale. Received the recorded like August 22nd. He was put on notice through VA tax.
All right, so you bought the tax sale and he was in it.
Right.
All right, now you want your property, so you want him to move.
He's not actually the owner either.
All right.
By record. He's just basically an old tenant of whoever was. I just bought the property. I've owned it and I have never even been inside of it. I give him an opportunity.
All right, well, so Mr. Swank, do you pay any rent to anybody?
No. The previous owner was Josh Denny, who I paid $10,000 to. And he failed to provide the paperwork and the deed. And he had a tenant staying there who was gathering the mail. So I did not have any awareness of the tax sale.
Well, they also posted on the door, but you're in very precarious position. You're called a tenant at sufferance. The person that owned it got $10,000 from you, I guess, as free money. You didn't get a lease. You didn't have a sale agreement. Mr. Appleton bought this matter at a tax sale quite some time ago. That takes a year or two for that to happen. So you've probably been living in there for several years without making any payment. He now owns it because he bought it at a tax sale and he wants to be able to use it. So the bottom line is, no wonder probably no one would help you because the facts don't sound like they're real good in your favor. But I'm gonna let you talk to Ms. Bauer from Legal Aid, but if Mr. Appleton gets what he wants, you're gonna have to move out. Now, I'm gonna continue this matter. I have to continue it at least 7 days. To 11:15 on November 17th. Mr. Appleton, does that work for you?
Like the judge.
You had a pretty hefty drive up here from Fremont. You live in Fremont now?
I'm pretty good now. It's a
All right.
lot better than it was.
All right, so I also need the breakout room for a discovery hearing, but we'll see how that goes. Mr. Swank, I'm going to put you in the breakout room so you can talk briefly with legal aid. And then we'll take up our other matter here. Every time I try to do more than one breakout room, I get all sideways. So I'm gonna, screen's gonna come up, it says join. And legal aid. Oh, very good. Well, we're not doing real good here. All right, there they go. All right, our next matter is discovery hearing. And then we'll deal with Ms. Salisbury's case. This is a small claims matter. Stick around for just a minute, Mr. Appleton. We'll see where they're going. This is Dr. Joseph Smolars. Mr. Swank, hit the button that says join.
I don't see no buttons to join.
Well, it should. We had a small claims hearing some time ago, and Ms. Leilani Taylor is the agent for Dr. Smolars. They sued you for $353 for failed to pay for dental service. You did not show up. Meg, he's having trouble. Now he's joined.
No,
I thought he did. Why don't you just give him your phone number and he can call?
Yeah, I was just thinking that. Okay.
All right, Mr. Swank.
Do you have a pen?
Yeah.
Okay. The phone number you need to call is 269.
Yeah.
366. 3385.
3 what? 85?
3385.
Okay.
All right, you're good to go.
The 15th at what time, Judge?
It would be the 17th at 11.
First you said 15th.
November 17th at 11:15.
And she's still in good health, Judge.
All right. It's nice to see you. Who'd you bring with you?
That is my youngest.
Oh my.
That's Raymond.
I remember when you were a baby, but
That was probably started in the ponytail.
yeah, probably. You haven't been here in a while. That's probably good. So, all right, I'll see you.
They got me as a disabled vet, almost 100%.
Oh, sorry to hear that.
And stuff.
You had a lot of irons in the fire.
I do now, yeah. Once I get rid of all the other kids, taking all my stuff.
All right.
17th is nicer.
Okay. All right. Let's go back to this, getting a little here and there. Anyway, this was a default judgment, and I made a finding by default that Mr. Kabaziak owned owed $397.17. In an effort to collect on that, they served a subpoena for discovery on Mr. Kubasiak, trying to collect on that debt. Mr. Kubasiak, I don't know if I did this, but I'll do it again if I didn't. Would you raise your right hand? Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
Yes.
All right. I made a finding that you owe this money. Ms. Taylor, what's the total now?
After the process server fee, the total is $463.71.
Mr. Kubasiak, do you have the ability to pay that?
I was looking to pay it on the 17th. I just started my new job, and that's the day I get paid.
Well, we don't have to take it all out of one check. If you can make some.
Paying it all in full.
All right, I'll tell you what. The 17th is a Friday. When do you get next paid after that? December 1st?
It happens every 2 weeks.
All right. I'm going to make this due by December 4th. That gives you 2 paychecks.
Okay.
If you pay it all at once, great. Now, everybody likes Dr. Smolars, and everybody knows that they may need their dentist again. This bill isn't outrageous. You didn't show up for the hearing and you got defaulted. But if you pay it, this matter will be done and you'll be able to get on your business.
Okay.
The last case we just did was also Driftwood Drive, a little down the road from where you are. Go pay this, make Leilani happy, make Dr. Smolars happy. Next time you need a dental appointment, you can get in and see your dentist. Where's your new job?
Denzo in Battle Creek.
All right, that pays a good wage there. Good luck for you, sir.
Thank you.
Ms. Taylor will be there to take your money. You can pay it in 2 payments when you get paid on the 17th and then on the 4th, or just pay it all at once.
Okay, sounds good.
All right, very good. You're good to go.
Thank you, Your Honor.
Thank you, and thank you for letting me move that case up.
No
Miss
problem.
Salisbury, are you lurking in the background somewhere?
I'm here, Your Honor.
Good afternoon. I had kind of accelerated things. I'm on a time crunch here, but we seem to be doing all right. Your hearing was set for 1:45 and the defendant is not here. This is Omni Community Credit Union versus Scott Wiki. The file number is 23900GC. It is a judgment. Trying to find the original judgment. For north of $25,000 with costs. And you've been attempting to collect on this through garnishment or other means for some time. What's the current debt?
The current debt, there's been no payments on this judgment, Your Honor.
With costs and interest, and do we know what it's at now?
Unfortunately, I don't know with interest what, I do know the employment that the defendant had given us was no good. So I can't apply those costs, but I'm not sure what the interest is as of today.
Well, the judgment was $24,454. And I'm sure it's north of 25,000 now. He had been a particularly difficult client. Think did not have much intention to pay on this debt. I'm not gonna do a show cause. Let me make sure he was personally served. He was personally served by Sergeant Morse for today's hearing, and he is not here. Let me call, make sure he's not. Hello, Deputy Metz. I'm looking for a Scott Wiki. All right, thanks. Bye. He's not here. And I'm gonna skip the show cause step. Ms. Salisbury, you know that we often do that. But I'm gonna find he's in contempt for failing to appear on personal service. I'm gonna do a bench warrant. Bond, $1,000, cash only. I usually do 500, as you know, but this debt is so large that he'll either have to post the bond or see me. And if he is apprehended, we will contact you. What Sergeant Morse usually does is make an effort to tell him, hey, there's a warrant for your arrest. Bring $1,000 or I'm going to take you to jail. So if anyone knows Scott Wiki or Wick, I'm not sure how you say it. I don't remember. W-I-C-K-E. Tell him there's a warrant for his arrest for failing to appear on a duly personally served subpoena. The bond is $1,000 cash only. You cannot go through a bonding company. Because he's failed to appear for this hearing regarding her ability to discover. So we'll see what develops. I don't know if he's still in the area. This is a 2023 case. Let me look in here and see if we have anything else. He doesn't owe me any money, but he owes you some. All right, if he comes with the money, we'll set a hearing. If he comes without the money, we'll contact you and set a hearing. All right, anything further?
No, Your Honor, thank you.
All right, thank you. Thanks for coming in early. All right, we're about where we need to be, Meg. That finishes the general civil and the discovery matters. What we have now, we did the 2 Riverside cases. And Stone House Apartments is 240. And the Riverwood apartment case is dismissed. So we have 1 case left. This is a continued case. We're here on October 30th. Mr. Fleeman was here. And we made some progress. So hopefully they'll be here and we can get on our way.
And I did not see Miss Stewart in our system. So at this point, it would be probably too late for us to get involved, unless you're interested in having legal aid involved, in which case.
Well, let's see what my notes say. Got so much stuff up here. We have a visitor from Seattle. He came here to get out of the rain. And he spent last night in Kalamazoo. And if someone came to Kalamazoo, where would you tell them to go?
Would depend on what they were interested in. We've had a lot of great live music options going through town. I think there was a blues competition last night.
Yeah, there was at the Old Dog, but where would be your #1 recommendation for him to go if a brand new visitor to Kalamazoo?
For food, I'd say Crow's Nest.
How about for beer?
Oh, well, bells, of course, certainly. Yeah.
Well, he beat you
Thank
to
you
it.
for keeping
He's already been to Bell's.
I was there this
So
weekend, actually.
that's the #1 tourist attraction in Kalamazoo.
I'm ashamed of myself that I had to be spoon-fed that one, Judge.
Yeah, sorry. I thought you'd go right into it.
I should. I'm ashamed.
Mr. Becker is here from his world headquarters. We don't usually see him from there, but are you here on the Nicole Stewart case?
I am.
All right. She indicated that she was going to be here. And so we're waiting for her. Mr. Fleeman was here last time, and I don't know where Meg was, if she had left earlier, what happened. It's a non-payment of rent case. And he indicated that he would have you here early, which I appreciate. So her rent is currently at 0, but there's an arrearage that they've been working on. The arrearage, I think, was $1,460.48. If we added November, it was another 108, which gave us $1,568.48 through November. Is that what you showed, Tom?
I'm not. I've got, they're showing a rent to retain through this month of $1,996.63. Also $186.85. It looks like she has it looks like her portion of the rent is 108, and there's a voucher.
108, that's what I was advised.
Yeah, but her rent is 108. There's a voucher amount of 600. That looks like it hasn't come in. So that's part of one of the charges.
Yeah, we were waiting for RDH voucher of 600.
And it looks like that would come through on about the 10th.
Miss Stewart, can you hear me?
Yes, I can. Are you there?
Yes, I'm here.
Oh, good. Sometimes my phone hates me.
Me too. Mr. Thomas Becker is here today by limited appearance on behalf of the Bradshaw and Fleeman office, behalf of Stonehouse Apartments. We made quite a lengthy record last week with Mr. Fleeman.
Yes.
And your manager, Jessica, trying to figure out what the rent was. This is filed as a demand for non-payment of rent. Mr. Becker, what's the current arrearage?
Through the month of November, we're showing $1,996.63, cost of $186.85 for a total of $2,183.48. It looks like that voucher payment should be made, that 600 should be made anytime, I guess, but it's not in the ledger yet.
And we determined that her share is 108, and I think now it might even be at 0. I wasn't clear on that, but there's a lot of back payment that needs to be done. As I indicated, this is a different number than we came up with.
Yes.
We had 1,273.63 through October. And I added only her 108. You added the entire market rent of 708. So that gives you the 1,996.63.
My rent was 108 a month.
Yes. And then the voucher was 600, which makes it total 708 per month. What's the status here, Miss Stewart?
Well, my daughter was gonna help me this past weekend, but she had to go to a funeral. Her son, my soon-to-be grandson's brother died, so gonna have to wait till next weekend.
All right, well, you've got some additional time. Now, Miss Flores was there. And you're working with your caseworker also?
No, who's my caseworker? I'm sorry, this is new to
Well,
me.
who was paying this, the other $600?
Oh, I have no idea. I think the voucher was.
Yes.
It's like I told her, I sent her a voicemail yesterday. I would like to come back, but I can't afford the 1,700 or whatever amount it is now.
Well, you're not even living there, is that correct?
Not at this point. My stuff is still there, but I told her they asked if I wanted to move back, and I was like, I would like to, but I can't afford the amount to come home to. You know.
Well, you have 10 days from today to pay that amount or move.
Okay.
And so
yeah,
10
my
days
daughter.
from today.
Go on. I'm sorry, sir.
10 days from today would be November 23rd.
Correct. That's on.
No, excuse me, November 16th. Today's the 6th, November 16th.
All right.
All right, November 16th, and your stuff has been there for some months without you in it, and they're paying this voucher, and there's someone who would like to have this apartment.
Oh, I understand.
I suggest you stay in contact with Miss Flores.
Yes. I sent her a voicemail yesterday, but she never called me back, so I don't know if she got it or not, because I called her yesterday with my real phone number. So,
right. Well, perhaps she will if she doesn't try again, but you're going to need to get your things out of there.
Yes, sir.
Like
I said, my daughter was going to do it, but
you also have 10 days to appeal this.
I would like to.
You'd like to appeal it?
Yeah, I'd like to try to come home, but I can't afford the amount.
Well, that's the problem. You haven't been there.
I only make like 900 a month. You know.
Yes. Mr. Becker, would you either yourself or ask Mr. Fleeman to send me a judgment?
We'll do so.
Now, let me tell you a couple of other things.
Yes, sir.
If you move, which it sounds like you're going to do, you're really not even there and haven't been there for some time. You need to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. Stay in contact with Jessica. I'm not ordering you to pay this money, $2,183.48. I'm ordering you to pay it if you wish to stay there.
I would like to, but yeah, that's kind of hard when I don't have that much.
Well, a couple things. One, you don't have the money to afford it, and B, you're not there. So you're paying an awful lot of money for a storage unit for your stuff.
Correct.
And you're taking care of a friend, and
it's my boyfriend and his kids. Yes.
Yes. So plan on vacating unless you pay that money. When you do vacate, turn in your keys and give your forwarding address in writing within 4 days of your moving.
Okay.
All right, Ms. Stewart. Good luck.
Well, thank you, sir. I appreciate it.
Thank you. All right, Mr. Becker, thanks for covering for Mr. Fleeman since I moved that case ahead.
No problem.
All right, Meg, thank you for your help. I've kind of been all over the map today. Next Friday, the 20th, the 22nd. We'll see you next time.
Thanks, Judge.
All right.
Thanks, Judge.
You. All right, that finishes our day. And gotta get on my horse to make a flight for somebody. Be back in the morning with a very busy docket. Again, I've got both mine and Judge P's docket tomorrow.